Well, the complaint that was filed was that the federal government as an employer discriminated against its gay and lesbian employees who were not able to put their same-sex spousal partners on the benefits plan. You were prohibited from doing that because your spouse was defined as someone of the opposite sex.
It just snowballed. It started from a case of a couple here, and Dale and Alex in BC, just looking for benefits for themselves. And it grew from that into something that was going to transform not just granting of benefits to gays and lesbians, but granting recognition and status by even allowing them to use the word spouse for the first time.
This was quite important at the time because there had been efforts to seek relief under human rights statutes on the basis of family status. And that argument largely failed. And so until there was an acceptance that human rights legislation must be read up to include sexual orientation, a lot of those claims were doomed to failure.
What was interesting about the Akerstrom case is up until Akerstrom, my memory is that PSAC, was Public Service Alliance of Canada, was not very involved in human rights cases because the attitude or the policy was at the time counsel was provided to the complainants by the Human Rights Commission, and so the PSAC was not actively working with human rights complaints because the belief or the thought was that anyone who was filing a human rights complaint was going to be represented by legal counsel from the Commission, and our focus was elsewhere. Akerstrom changed that.
The no discrimination clause came in during negotiations for the master agreement, and it was a small step in the right direction. But of course, one of the big missing parts was the same-sex benefits, and that came in subsequently in 1989.
Well, I started working for the federal government in 1990, and Alex and I got together that year, towards the end of that year, and after we'd been together for a year, I knew that year of being with someone was the definition of a common law spouse as far as federal government benefit stuff goes. And so it was actually 1992, so we'd been together almost 2 years, that I thought I would apply to put Alex on my benefits plan. But of course, you couldn't do that. It was refused because the benefits plan specifically excluded same-sex partners of employees from being registered for payment of benefits like the extended health or the dental or the medical things.
We went on our posting in 1991. In the summer, and just prior to that there was a change in the collective agreement between the government and PAFSO, the Foreign Service Association, where they added a non-discrimination clause which said that all of the provisions and clauses outlined in this collective agreement will not discriminate against anyone based on sex, religion, age, or sexual orientation. That was a new addition. So based on that, Pierre and I decided to apply to have the expenses that we incurred in him accompanying me, to have those covered by Foreign Affairs. Up to that time, they were tolerant in allowing Pierre to join me. But they would not recognize him at all.
We live in a country where we have a lot of guarantees of equality and equal rights, but it seemed like there was a number of things, at least in the 90s, that were still lagging behind, and that was one of them, that gay families weren't considered equal to straight families. And so myself and my same-sex spouse, common law spouse, were not seen as a family the same way as my colleague and their straight common law spouse. And I just wanted to make that, to eliminate that difference in the way our families were viewed.
There was really very little going on at that point in the public service. I mean, there were no benefits being provided, not only abroad but domestically. So I think what began to encourage us was introduction of clauses such as the one that Stan mentioned earlier, saying that there was to be no discrimination. So we made the assumption from that we could apply for benefits that were being provided to opposite-sex couples, which we did. And in fact, I remember distinctly sending a telex to Ottawa, asking them which benefits we could be entitled to, given this new clause, and they responded, well, that was not the intent of the clause. It was just to give equal standing. And we then asked, well, then what's the purpose of the clause? And we never got a response, not a word.
I think to understand Akerstrom and Moore and how it evolved in the jurisprudence around same-sex rights and benefits, you have to understand where the Charter of Rights and Freedoms was at that time. Charter came in the early 80s. We didn't have a whole lot of guidance from the Supreme Court of Canada on how it was to be applied in practical terms until around the middle 80s. And it was only at that point, 86, 87, that people started thinking about using the Charter to further human rights causes and cases.
There was a lot of frustration within the membership, the lesbian and gay membership, right through most of the 80s, when there was a push for equal rights. But the courts were really not going along. They were interpreting matters in the most restrictive and absurd ways. There was one court case in Manitoba in '88, a Court of Appeal case, I think, Vogel, where the judge actually said that even though the requirement of a spouse being of the opposite sex had the effect of denying benefits to gay and lesbian employees, it was not discrimination because those gay and lesbian employees had the same right to that benefit. All they had to do was to have an opposite-sex partner. And he was saying this seriously, so the state of things was pretty bad, and people could have given up because there was a solid no until the late 80s, early 90s.
And so, as cases were running through the courts addressing these issues and human rights standards were qualified, the issue of sexual orientation arose in the early 90s and came on like gangbusters between about 1990 and 1999.
Well, there were breakthroughs, and that's what I was saying. It was, the PSAC, we were just one child of many children that were taking on this. But now, as I say, in retrospect, it just seems so ridiculous we had to do it. But let's back up when we had to do it. There were unions that were taking cases, and there were cases which we all were excited about that we didn't initiate.
Yeah, there was a split in the union for those who believed it was legit to have same-sex benefits, and those who thought that if we put that in, that it might take away some of the benefits they could achieve. Now, the split wasn't a major split except for some of the bargaining unit.
one of the things that you really have to understand as respondents, Treasury Board took the position that we were jointly liable, and there could be a significant financial repercussion from this case. So you have on one side, the PSAC is very supportive of what Brother Akerstrom was trying to accomplish. On the other side, there was a very real sense of this could cost us a fortune. And that was one of the interesting things, at least for me, in a legal sense, came out of this case, because up until then, Renault was out there, where a union was found by simply signing a collective agreement which was discriminatory to have discriminated itself. And so we had to sit down first and get directions from the elected leadership of the PSAC what our position was going to be in Akerstrom.
During the 80s, late 80s and the early 90s, I think the biggest thing was that the gay and lesbians were getting really active in the union. They were really pushing, and as I say, I will admit that it took a while to get me to understand it. And when I pursued it with them, it actually made a big difference. Because now that I understood the situation, knew it was discrimination, then I was able to talk to CLC, or Canadian Labour Congress as an example, and a number of the leaders there were able to then grasp it. And at one of the CLC conventions, there was about 4 major leaders, including myself, who got up and spoke openly against it, the discrimination. And that certainly made a difference for all of the other unions.
The reason that the Alliance was active on this front, that's the way it should be, is that members, a certain segment of the membership, supported by many others, really got out there and they were filing the grievances, they were making the demands, they were educating the leadership of the Alliance, as well as the staff and everyone else, on the need for this type of activity and action to obtain simply the same rights that everyone else had.
There was a resolution very early in the 80s, coming out of the PSAC, that we had to change this. So that engine, the engine of what happened in Akerstrom 10 years later, I suppose, it started with the membership passing a resolution that the PSAC had to take this on.
It was very satisfying in that way because it worked the way it should. It really was from the membership. And the leadership was principled and supportive. And the staff was interested. It was a real privilege to be in the position where you could be on the right side and push for things and actually make some progress within what, as these things go, was a relatively short period of time. It seemed like a long time, certainly a long time for people denied basic benefits and rights.